Hello and welcome to another in the 10-minute tip series of recorded programs for credit and collection professionals. This program is titled Laws and Rights That Benefit Business-to-Business Creditors. My name is Michael Dennis. I'll be the presenter today. Let's begin with an introduction. In the U.S., it seems that many laws are written to benefit debtor companies, and I would offer as examples Chapter 7 and Chapter 11 of the U.S. Bankruptcy Code. However, some laws benefit creditors to the extent that they create rights and remedies for the creditor company. Today, we're going to explore various legal rights and legal remedies that you have as a business-to-business creditor. These are rights and remedies that make it more likely that you or we are going to be able to collect the money that's owed to us by our customers. Let's talk about liens. So a lien is a claim against property. As it relates to liens that are important to creditors, there are two primarily. They are mechanics liens and judicial liens. So let's start with a discussion of mechanics liens. When a creditor company provides labor or materials or services to make improvements to real property, that creditor company can place a mechanics lien on the property itself. In this scenario, the property becomes security for the debt. In other words, it makes it more likely that you're going to be paid if you have a lien on the property. In addition to mechanics liens, there are judicial liens. Let me explain that. If you as a creditor sue the debtor company, the reality is that you may or you may not be able to collect the amount that's awarded by the court. You may be able to collect all of it, you might collect some of it, and you might collect none of it. If a judgment by the court is unsatisfied, in other words, if you're not paid in full, you as the creditor can ask the court to impose what's called a judicial lien on the assets, on the property that's owned by the debtor company. Once that judicial lien is in place, the next step is to go to the court and request what's called a writ of execution, at least in some jurisdictions. A writ of execution permits you to order an officer of the court to seize the assets of the debtor company. The next step is to sell the assets of the debtor company, and the third step is to pay your company from the proceeds of the sale of the assets. Now, to the extent that there's money left over, that money would go back to the debtor company. Guarantees. The typical business-to-business credit department often requests some type of guarantee of payment in return for a decision to extend credit to a customer. So let me illustrate that with a fairly common and simple example. You're a creditor company, you've just received a credit application. The applicant company has requested a $10,000 credit limit. You've done your analysis. You've determined that the applicant company is not creditworthy for $10,000. However, you might at that point request a personal guarantee. And that might be the difference between granting the $10,000 credit limit and not granting the $10,000 credit limit. So you might say, in the context of sales to a corporation, you might say to the officer of that corporation, we'll grant your corporation the $10,000 credit limit it has requested if you will sign a personal guarantee. In addition to personal guarantees, creditors sometimes request and receive what are referred to as intercorporate guarantees. So an intercorporate guarantee typically comes from a related company. And let me create a scenario once again. Let's assume that you've just received a credit application requesting a $100,000 credit limit, and you've done your analysis, your evaluation, and the applicant company does not qualify for the $100,000 credit limit. At that point, the parent company might intervene. The parent company wants their subsidiary to succeed, and part of wanting that subsidiary to succeed is wanting to ensure that the subsidiary company receives the products that they want to purchase on open account terms. So in connection with extending credit to the subsidiary company, A parent company will often either offer or agree to sign an intercorporate guarantee. The parent company then becomes the guarantor company. The guarantor becomes contingently liable for obligations incurred by the debtor company. Just to make that a little more clear, what happens is that you look to the subsidiary first for payment. You expect them to pay you. In the event that they do not pay you and you have an intercorporate guarantee from the parent company, you would then go to the parent company and demand payment from the parent company based on the contractual obligation that they have signed in connection with the intercorporate guarantee that you have on file. I think it's important to recognize that intercorporate guarantees and personal guarantees need not be unlimited. Unlimited as to the dollar amount of the guarantee, unlimited as to the time or duration of the guarantee, or unlimited as to the scope of the guarantee. So you as a credit decision maker, in connection with receipt of a guarantee, need to read it carefully to make sure that you understand whether or not it is limited in some way. And here's an illustration. Let's assume that the parent company does intervene in connection with your decision not to extend credit to their subsidiary, and they provide you with an intercorporate guarantee. It might be the case that that guarantee is unlimited as to duration. It is an ongoing intercorporate guarantee, which would be good. On the other hand, the parent company might create an intercorporate guarantee that says that the duration of the intercorporate guarantee is 90 days, is exactly 90 days. And that, from our perspective, might be a concern because we presumably intend to continue to ship product to this particular subsidiary company, but we are basing that decision to extend credit on the intercorporate guarantee, I should say. And if that intercorporate guarantee expires in 90 days, well, that is a concern for us as creditors. Other rights that benefit creditor companies. Your rights include the right to file a UCC-1 financing statement and, in effect, to become a secured creditor. The creditor always has the ability to sue the debtor for payment. You have the right of reclamation under either the UCC or under the U.S. Bankruptcy Code. You have the right to factor accounts receivable if you choose to do so. You have the authority unilaterally, with or without advance written notice, to either increase or decrease a customer's credit limit. You can sue a debtor in small claims court. You have a right to offer or to request factual historical credit information about a customer or an applicant company. Your rights continued. You can propose or require that customers pay you on any payment terms, including but not limited to cash in advance or cash on delivery. You have a right to decide to accept or reject a proposal that you ship products on consignment terms. You can purchase credit insurance with or without notice to your customers. You have the right to join and be active in one or more industry credit groups. You have very specific rights if a customer bounces a check. You can request at any point in time or require a letter of credit or a standby letter of credit from customers and from applicant companies. If a customer is past due, you can contact them by email, you can contact them by mail, you can contact them by phone, and you can contact them in person to collect the past due balance. Other rights continued. You as a creditor have the right to charge interest on past due balances. You can propose alternative dispute resolution mechanisms in the event that there is a dispute, including but not limited to mediation and binding arbitration. You have the ability and the authority to refuse to sell to any customer at any time, and you can decide at some point to shorten the payment terms. For example, changing the payment terms for an existing customer from net 30 days from date of invoice to net 15 days from date of invoice. Thank you for your time. I hope you found this presentation to be interesting and helpful. If you're interested in more information on this topic, if you're interested in a 1-hour on-demand program, here's how to request that. Again, thank you very much for your attention.